All right, good afternoon, everyone. Are you able to hear me?
Yes. Good afternoon, Your Honor.
Good afternoon, Your Honor.
Good to see everyone on this fine Saturday. This is a state expedited accusations calendar. This calendar is for those individuals who've been recently arrested, or the cases have already been formally accused and bound over to state court. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of this case can and will be used against you. You also have the right to an attorney at this proceeding as well. All participants, this particular proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch this. All right, who do we have first?
Position 15 here at South Annex.
All right, good afternoon. Are you Deshaun Watkins?
Yes, ma'am.
All right, Ms. Watkins, I'm Judge Melanie Williams. Your case number is 22 CR 008088Y. In this case, you're charged with battery with the offense date of September the 23rd of 2022. Do you understand those rights that I just explained?
Yes.
All right. Is pretrial on the line? All right, I don't see anyone from pretrial. I'll go straight to the state. Whose case is this for the state?
Good morning, Judge. That would be me, ASG Waldrop for the state.
Good morning, it's afternoon. Good afternoon, Ms. Waldrop.
Good afternoon.
It's been quite some time. Please proceed with the state's recommendation, please.
Yes, Your Honor. With respect to the state's recommendation, the state is recommending a $5,000 straight or good bond on the charge of battery. Your Honor, we would also be asking that the defendant have no further contact whatsoever with the victim in the case, and that she stay away from the incident location, which I have as 2500 Center Street, and that is in Atlanta, Fulton County. Your Honor, we would also ask that she have no alcohol or drugs while out on bond, no weapons on or about her person. I have the victim's name as Kenyatta, that's Kenyatta Banks, Banks. And Your Honor, just a brief factual basis with regard to the charge, and it stems from an incident in which the defendant grabbed the victim by her hair, causing her to fall. The defendant then kicked the victim in the head before another bystander broke up the fight.
All right. Thank you, Ms. Waldrop. And Ms. Kim, is this your case?
Yes, Your Honor.
Ms. Kim, please give me your recommendation.
Yes, my recommendation is for signature on bond on secure judicial relief. She says that she has been actually detained, arrested from November 22nd, 2022. So she's been in jail for a while. I think she was going through the seizures. She does have a serious medical condition that she needs to take care of. She has been collecting disability checks, and she is qualified for public defender's service, and she has no financial means to pay for any bond. She has been here in Georgia for 29 years, all her life, and she has 4 minor children right now. And her mother, who is a grandmother of those 4 children, are taking care of them right now, and they have no child support from the father of the children. So we would like to request for signature on bond for her. Thank you.
Thank you. I'm sorry, Ms. Waldrop, did you have this defendant's history?
I do, Your Honor. I show a prior theft by shoplifting conviction from 2016. I also show a prior battery and disorderly conduct. Your Honor, they appear to be convictions because I do show probation violations for those, and that's from 2020.
All right, thank you. All right, in light of that history, anything further from either the state or defense?
Nothing further, Judge.
All right, hearing none, defendant will receive a $2,500 surety bond. She's to have no contact with the alleged victim, last name Banks. I'm gonna sound for Ms. Banks at this time in the event that she's on the Zoom conference. All right, I don't see Ms. Banks. She is to stay away from the incident location. Should she need to, she can return one time with a member of law enforcement to get any items, and she's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Your Honor, I just want to double check that if her issue is not a Riverside issue. She says that she has been detained from November 22nd, 2022. Can we verify? with
Okay,
the
let's
bureau?
check. Yeah, let's check and see if she's been booked in that long on that charge. Or was she booked in on something else? Are you able to see Ms. Waldrop?
I'm trying to pull it up. I've just got a circle that's rotating, but as soon as I'm able to pull it up, I can advise the court. And I do believe that this may have been prior resets on the part of the defense. There may have been some medical issues. I'm not sure. I'm just showing a reset in my notes.
Okay. Well, let's clarify, because if it is Riverside, we would need to address this differently.
Sure.
Mr. Jordan, are you able to see either? And as a reminder, anyone who receives a surety or cash bond today will be reset to the state all purpose on December the 15th.
I can't see that she was holding at any other jail. It does look like she came in. Let's see here. So it looks like she may have had a charge at the city of Atlanta, but I'm not sure what the arrest date was. So
All
she
right.
may have been holding at the city of Atlanta on a charge, and then they brought her over to Fulton County.
For this charge.
Yeah, sure. I show the bookend date, obviously, in Fulton is from 12/1 of this
Okay.
year, so just a couple of days ago.
Okay.
This happened on October 29, 2022, Your Honor. If you see the warrant, it kind of says September 23, 2022 to October 29, 2022. It's very broad. However, it is definitely before November 22nd. Arrest warrant was issued and she was arrested in the city of Atlanta, but she was there for a long time. And then she just got transferred to Rice Street, December 1st, 2022.
Okay. And when did she arrive at the Fulton County Jail? Are we able to see that? 3 days ago, is that correct?
I show 12/1/2022, and I also show that this case was a previous reset.
Okay. All right. Out of an abundance of caution, as there may be some outstanding issues, we will convert this to a signature bond through the jail with the same conditions that she's to stay away from that victim. I mean, she's to have no contact with that victim and stay away from the incident location and have no alcohol, drugs, or weapons.
And Your Honor, just to confirm, I do show it as a medical reset. So it was a reset on the part of the defense for medical reasons.
Okay. All right, we'll still do the signature bond at this time. All right.
Thank
All
you.
right. Best of luck to you, ma'am. All right,
That'll be all for 5 minutes, Your Honor. May we be excused?
of course. Have a great rest of your weekend.
You too, ma'am. Thank you.
Good afternoon, Judge Williams.
Good afternoon.
Next, we have position number 4, Mr. Samuel Bryan, and he also has his mother in the galley.
Okay, thank you. Has courtroom 2 heard their rights? I'm assuming so.
Yeah, they did.
Okay, Mr. Bryant, your case number is 22 CR 008109Y. In this case, you're charged with simple battery family violence with the offense date of June the 20th of 2022. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard, can I have the history?
Fifth arrest. Last arrest was on the 1st of this month out of Henry County. Driving without a valid license. He has an open air assault in Superior Court. It's 20 CP 190115. 2019 trespass bind over. And a 2010 theft by taking that was dismissed.
Okay, that's it. Thank you. Mr. Taylor, please proceed.
Yes, Your Honor. The facts of this case is that the defendant was using the victim's car and the victim called him and requested that he return home. Once he got home, they got into an argument about him returning late, and he punched her in the face, the temple, and the lips before fleeing the scene. Given that he does have a pending aggravated assault and is currently out on a $10,000 signature bond, in this case, the state would be asking for a $5,000 cash bond, 1 anger management class, no contact with Lauren Scott, and to stay away from the incident location, 3390 Fairburn Road, Southwest, and it's apartment Q280, and that's in Atlanta, Georgia.
All right, thank you. Before I go to you, Mr. Howard, I'm gonna sound for the alleged victim, Lauren Scott. Ms. Scott, I see you on the Zoom conference. You're not required to make a statement, but if you wish to make a statement, this is your opportunity to do so. Do you wish to make a statement today? If you do, I need you to turn your camera on so we can identify you.
Yes, I do wish to make a statement.
Okay, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, I agree. Oh, I
All right,
understand.
thank you. Thank you. Yes, put your hand down. What the court is most concerned with is whether you'd like to have contact with the defendant. Please proceed.
I would like to have contact with him. He and I lived together, and it was a situation that turned bad, and I didn't want to press any charges. I just feel like kind of got out of hand. We separated for a little while. We had a conversation about it. Everything turned out okay, but I don't really wish for any type of legal action to happen to him.
All right. Thank you. I appreciate you coming to court and making that statement. Mr.
No
Howard, please proceed, Mr. Howard.
Yes, Judge. Good afternoon. Mr. Bryan is 35 years old. He is a lifelong resident of the state of Georgia. He attended Mays High School right here in the metro Atlanta area. I believe his mother is in the gallery today in support of him. He works full-time for General Wholesale. He has a minor child, 12 years old, that he financially supports and is emotionally involved with on a daily basis, Judge. And Judge, you heard from Ms. Scott, and we would note that this is an allegation from June of this year. They have lived together in harmony since that time. There haven't been any further incidents or any allegations of any type of violence since that time. We would ask the court to take that into account, as well as Ms. Scott's wishes, and we would ask for no further violent contact so that they can continue to reside together. We would ask that the court consider a signature bond in this case. The open aggravated assault is not related to her in any way. It is related to a male, which it's my understanding was threatening Mr. Bryan. He has text messages and other things that he's provided to his attorney to indicate that this was a case in which he defended himself. So we believe at a further, once this case is ultimately fleshed out, that he won't have this as a pending charge. So we would ask the court, given that he does not have any other allegations of violence other than that open case for which he's presumed innocent, that he be allowed to sign his own bond in this case.
All right, thank you. All right, at this time, the defendant is going to receive a $10,000 surety bond. He's to have no further violent contact with the alleged victim in this case, and he's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Judge, I would ask if the court is inclined to give a surety, the court might consider maybe half of that so that his family would have the possibility of bonding him out, given that he does not have any convictions for violence. We would ask the court to consider a reduction from the 10,000 surety, Judge.
The 10,000 surety will stand, Mr. Howard.
Right. Thank you, Judge.
He'll be reset to the SAP calendar on 12/15, whereby that bond amount could be revisited.
All right.
All right, best of luck to you, sir. Who do we have next?
Next, y'all, we're gonna go to courtroom 3. We're gonna go to courtroom 3.
All right, who do I have at courtroom 3?
Judge, position number 2, please.
All right, are you Sydney Armour?
Yes, ma'am, I am.
All right, your case number is 22 CR 0081006B. Has courtroom 3 heard their rights?
No, Judge.
All right, all defendants, please pay attention. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney at this proceeding today. This particular proceeding is being broadcast over the internet as a live stream. It is also being recorded. That means any member of the public can log on and watch this particular proceeding. Ms. Armour, do you understand those rights as I just explained?
Yes, ma'am.
All right, thank you. Mr. Howard, oh, this is first arrest, so we'll go
Yeah, I
straight
got
to this.
first arrest for this.
All right, we'll go straight to the state. Mr. Taylor,
Yes, Your Honor. The facts of the case were the victim was taking a shower when the defendant approached him and told him to leave the house. They got into an argument, and the defendant got out of the shower and began to collect his belongings to leave. As he was leaving, he realized that he left his laptop and turned around to get it. As he bent down to get it, the defendant began hitting him on the back of the head and then proceeded to hit him and scratch him in the face, which caused bleeding that the officers were able to observe. The victim and the defendant have been living together in an apartment since October 2002. Before that, they lived together in Birmingham, Alabama. The state would request a $3,000 surety bond, a 1 anger management class, no contact with David Austin, and to stay away from 740 Sidney Marcus Boulevard. That's apartment 9307 in Atlanta, Georgia.
all right, I'm gonna sound for Mr. David Austin. If you're present on the Zoom conference and wish to be heard. All right, hearing none, Mr. Howard, please proceed.
Yes, Judge, Ms. Armour is 29 years old. She moved here for work purposes about 3 months ago. She works for American Express. She is a branding manager there. And she has a master's in science in branding. She also is a proud member of our armed forces. She's in the U.S. Navy as a reserve. She's been in the Navy for 3 years. Just as the court heard, she has no prior criminal history. And of course, there's some dispute as it relates to the allegations in this case, but given her lack of criminal history, we would ask the court to allow her to sign her own bond. Judge, I was able to speak with Mr. Armour today. He indicated to me that he wishes to have no further violent contact. He is actually in the process of moving his things out of her apartment as we speak. Spoke to him probably about close to an hour ago. But he indicated that they're going to live in separate places, but he certainly would like to continue to have contact with her. So we would ask that the order be no further violent contact at this time.
All right, at this time, the defendant will receive a $3,000 signature bond through pretrial services. Because Mr. Austin is not here, Mr. Howard, I am going to issue a no contact order. That could be modified at a later time. And she is to stay away from the address on Sidney Marcus if the victim is still living there. If he's no longer there, she can return to that address. And we'll ascertain that with a one-time law enforcement escort. And she's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Yes, Judge. I told him I didn't know if the court would need to hear from him directly, so I will see if I can get him on before the calendar ends.
Yes, and if you can, we can change that. All right.
All right. Thank you, Judge.
Thank you. I believe that concludes Mr. Armour's case. Ms. Armour's case. Yes, Mr. Jordan?
So the address that was listed, that's not the same one that's showing on the warrant.
The address, the stay away address?
On the warrant, it says 5450 Glen Ridge Drive, Sandy Springs.
Okay, so
That's
Mr. Taylor, do you know what this Sidney Marcus address is?
Let
Or
me
should we
check. I
change
believe
it
I
to-
got that straight from the police report, but I will double check.
Because we can, let's clarify that address.
You just have a seat over there.
Yes, Judge, I can confirm the 5450 is the address where they were living jointly. But he did
Okay.
indicate, maybe that's the address that he is
That
planning.
he's going to.
Right.
All right, so we'll say the 5450 is the, if that's the address that they were sharing, we'll make that the stay away address, contingent upon whether or not the victim still resides there.
Okay.
All right,
Thank you, Judge.
thank you, Mr. Jordan, for that point of clarification. All right, who do we have next?
Position number 8, Judge.
All right, Are you Diamond London or London? All right, thank you. Your case is 22 CR 008112 F. In this case, you're charged with battery of family violence with the offense date of December the 1st. Do you understand your right? All right, as this is also, I have as first arrest, we'll go straight to Mr. Taylor.
Yes, Judge. The facts of the case were that the defendant and the victim were in an argument over lost keys. During the argument, the victim brought up another man, and the defendant punched him in the face. And by bringing up another man, I mean somebody that was potentially cheating on the defendant.
I think I've got that.
Okay, I just wanted to be clear because I realized it was a little
Yeah.
ambiguous.
That was pretty
Um,
clear. Go ahead, Mr.
Okay.
Taylor.
The officers were able to observe injuries to the victim's hand and face, and we would ask for a $3,000 surety bond, no contact with the victim, Tiande Coleman, stay away from 164 Lakeview Place, and to have one anger management class. And I believe the victim is online if they would like to speak.
Okay, I'm gonna sound for Mr. Coleman. And the correct stay away address is, I'm sorry, can you give that to me again, Mr. Taylor?
164 Lakeview Place.
All right, thank you. Mr. Coleman, you're not required to make a statement, but if you would like to, this is your opportunity. I just need you to turn on your camera. But if you want to make a statement. All right, we'll come back and see if he wishes to. Mr. Howard, please proceed.
Yes, Judge. Ms. London is 24 years old. She has lived in Georgia for a little over 10 years. She works for Comcast as a repair tech. She has been on that job for a little over a year. She does co-parent a 7-month-old child with Mr. Coleman and they do live at the 1300 Lakeview Place address. We would ask the court to issue a no further violent contact order in this case. Given her lack of criminal history, Judge, there's nothing to indicate that she wouldn't return to court. And she certainly doesn't have a history of any type of violence. We would ask the court to allow her to sign her own bond and be a no further violent contact in this case.
All right. Okay. Is that you that says iPhone X, Mr. Coleman?
Yes, ma'am.
All right. Do you wish to make a statement?
Yeah,
Wait,
no.
before you do, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, would you like to tell me what I'm most concerned with is whether you wish to have contact with the defendant?
Yes, ma'am.
All right, is there anything else you'd like to tell the court?
No, ma'am.
All right, thank you. Anything further from either party?
Nothing further, Judge.
No, you got it.
All right, at this time, defendant will receive a $3,000 signature bond through pretrial services. She is to have no further violent contact with the alleged victim in this case and have no alcohol, drugs, or weapons. Is there anything further?
No, Judge.
All right, best of luck to you. Who do we have next?
Position number 9, Judge.
All right. All right, good afternoon. Are you LaQuavia Rouse Mangano?
Yes, ma'am.
All right. Your case is 22 CR 008105J. In this case, you're charged with theft by shoplifting with the offense date of December the 1st of 2022. You understand your rights?
Yes, ma'am.
All right, Mr. Howard.
Second arrest, last arrest was back in March for suspended license. It appears to be open. She had the FTA warrant out of Jonesboro. That's it.
Okay. All right. Whose case is this for the state? Oh, Ms. Waldrop. Ms. Waldrop, please proceed.
Yes, Judge, thank you. Yes, this is a theft by shoplifting. She's alleged to have taken various food items from a Chevron station without paying. State would be recommending a $1,000 signature bond through pretrial services, a stay away from the address of 5370 Campbellton Fairburn Road. That is a Chevron gas station. That the defendant have no weapons on or about her person while out on bond, and no drugs or alcohol.
Your Honor, we would like to request for signature bond through jail. Miss Rose Many Galtz. She has been here in Georgia for 9 years, and she's qualified for public defender's office, our service, and she does not have any employment at this point. And this is only one of the few things that she actually is falsely accused of at this point. We would like to request for a signature bond through the jail. Thanks.
All right. At this time, defendant will receive a $2,500 signature bond through the jail. She's to stay away from that location on Campbellton Fairland Road and have no alcohol, drugs, or weapons as a condition.
Thanks, Your Honor.
All right. Best of luck to you. Who do we have next?
And Judge, if you have a moment, Mr. Austin has joined the call in relation to the Armour case. If the court would like to hear from him.
All right, let's temporarily go back to position 2.
Yeah.
Mr. Armour, would you like to make a statement? I'm sorry, Mr. Austin, would you like to make a statement?
Yes.
Before you begin, I need you to raise your right hand so I can swear you in. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes. I do.
All right, you can put your hand down. But the court, I'm going to allow you to make a statement, but what the court is most interested in is whether you wish to have contact with the defendant in this case.
Okay. But yes, I'd like to have contact, but nonviolent contact. But Ms. Armour is a young woman that's on an upward trajectory in her career. I don't want to see anything to derail her, even, bad choices. So, I pray that you would give her some leniency in this situation. I'm sure it was, I'm sure she learned a lot from it. And that's pretty much.
All right, so we will modify the Armour order such that she is to have no further violent contact with the alleged victim, Mr. Austin. All right.
All right.
Thank you for coming to court and making that statement. I do appreciate it. And best of luck to Ms. Armour. All right, I believe we've completed that position as well as position 9. Are we ready for the next position? And who do we have?
Your Honor, we have position number 1, Mr. Akins, position number 1.
All right, Mr. Akins, your case number is 22 CR 0081048. In this case, you're charged with battery family violence with the offense date of December the 21st of 2021. Do you understand your rights?
Yes.
All right, thank you. Mr. Howard, history.
15 total. Last arrest was November, failed to appear. That was out of Douglas County. It's for a traffic citation. 2019 misdemeanor possession of marijuana. 2018 probation, theft by taking out of Henry County. Sale of marijuana conviction, 2017. 2 counts theft by taking conviction, 2015. He had a battery DV, theft by taking, hindering person from making an emergency call. That was dismissed from 2015. 2013 probation violation. 2013 driving without a valid license. 2012 sale of marijuana conviction. He was indicted for forgery in the second out of the cab. That was back in 2009. And he got history out of Illinois as well. Last arrest, that was 2011 for forgery. That was dismissed. That's it.
All right, thank you. Mr. Jacob, Mr. Taylor, please proceed.
Mr. Honor, on December 21st, 2021, so this happened last year, the victim returned after drinking alcohol. She got home around 1 a.m. The defendant came home around 2 a.m. and physically assaulted her, causing a busted lip. The victim reported that this was not the only time that the defendant had beat her, and that he did it multiple times. She showed officers bruises on her knees from an incident from a few weeks before. He also damaged household items a day or two before this happened. We spoke to the victim, and she said that they broke up after this incident, and she has not spoken with him. We would ask for a $5,000 surety bond, 1 anger management class, no contact with the victim, Latonia Sanders, that's Latonia Sanders, and to stay away from 740 Sidney Marcus Boulevard, apartment 9307.
All right.
Good afternoon, Your Honor.
Good afternoon, Ms. McLeod. Good to see you. Please
Good to see
proceed.
you too. Yes, my client is 38 years old. He lives in Douglas County and has been living in Douglas County for approximately a year, Your Honor. He tells me that he did not, in fact, live with the alleged victim. They were in a relationship. He wanted to end the relationship and he was trying to leave her home and she didn't want him to leave. She kept holding on to him and trying to restrain him. In fact, he tells me that he has video footage of what actually took place between them. He denies that he was the aggressor here, Your Honor. He just tells me he was just trying to leave the apartment and she would not allow him to leave. My client is gainfully employed. He tells me he works at an auto body shop where he paints cars. He lives in Douglas County with his brother. He is the father of a 9-year-old child whom he is involved with, Your Honor. I acknowledge that my client does have some history of arrest and even convictions, but none of them were for any violence, Your Honor. Also, the incident happened approximately a year ago, and the prosecutor has stated that he was able to contact the alleged victim, and she says they have not been in contact at all for that entire period of time, which is about a year. Based on that, Your Honor, I would ask the court to consider giving my client a signature bond so he can get out of jail and get back to work and to taking care of his 9-year-old child. Nothing further, Your Honor.
I'm sorry, what was the victim's name? I need to sound for that victim.
It is Latonia Sanders.
Is Ms. Sanders on the line? All right, hearing none, defendant will receive a $2,500 surety bond. He's to have no contact with the alleged victim and stay away from that location on Sydney Marcus Boulevard. He can return one time with a member of law enforcement should he need to, and he is to have no alcohol, drugs, or weapons as a condition. Anything further?
Nothing further, Your Honor, but he never lived there.
Oh,
and he doesn't need to return.
So he doesn't need to go there. All right, so we
No,
won't
Your
add
Honor.
in that part. All right, best of luck to you. Who do we have next?
Next, we have position number 3, Mr. Willie Bethea.
All right, good afternoon, Mr. Batea. Your case number is 22 CR 008107G. In this case, you're charged with criminal trespass with the offense date of December the 2nd. You understand your rights?
Yes, ma'am.
All right, can I have the history, Mr. Howard?
7 total. Last arrest was 2020 ag assault. I was told it was dismissed back in October. Before that was an arrest from 1995 out of Tennessee, ag assault. So everything else is much older.
All right. All right, thank you. Mr. Taylor, please proceed.
Yes, Your Honor. The victim stated that on the day of the incident, he saw the defendant on his doorbell camera trying to enter his home. The victim asked what he wanted and for him to leave, but he refused to leave. The defendant then went around the house to the defendant's basement and tried to get into the basement through the side porch. He continued trying to gain access to the house, but couldn't get in. And refused to leave even when the victim commanded him to. The victim actually set off his home alarm so that the authorities could be alerted. The victim stated that he saw the defendant about a week before walking through the neighborhood, but does not know him. Because of the nature of this case and the previous 2 aggravated assault arrests, the state would be asking for a $2,500 surety bond to stay away from 2100 Fairhaven Circle and to have no contact with the victim, Andrew Billings.
All right, thank you. I am going to sound for Mr. Billings in the event that he's here. All right, hearing none. Mr. Howard, is this your case or is
Yes,
this
Judge.
All right, Mr. Howard, please proceed.
Yes, Mr. Bethea is 71 years old, Judge. He tells me that he has been here for a little less than a month. He tells me that he was only at the residence at the request of some other people that requested or allowed him to come. Housing is a challenge for him at this time. He would not be able to post any bond that the court would set. We would ask, given the nature of the charge, that the court allow him to sign his own bond in this case, because he just he doesn't have the means to post a bond otherwise.
All right. All right, at this time, the defendant will receive $1,000 surety bond. He is to stay away from the incident location and have no contact with the alleged victim. Is there anything further from either party?
Nothing further, Judge.
No, Your Honor.
All right, best of luck to you, sir. Who do we have next?
We got position number 5. Oh, sorry. Go ahead, courtroom 3.
I'm sorry, who's there?
Position
Who's that
13.
courtroom?
Position
All right,
13.
thank you. Thank you. All right, good afternoon. Are you Leah Stone?
Yes, ma'am. Good afternoon.
All right, Ms. Stone, your case number is 22 CR 008102E. You're charged with committing certain prohibited acts in a rail or bus station and 1 count of willful obstruction, each with the offense date of December the 2nd. Do you understand your rights? Can she be unmuted just to tell me she does or does not? You understand your rights?
ma'am.
All right, thank you. All right, Mr. Howard.
Second arrest, October 2021, shoplifting. That was out of Alpharetta. She got 12 months probation for that back in January. That's it.
All right, thank you. Whose case is this for the state? Is it yours, Ms. Waldrop? Who I don't see. Who's assigned to position 13? Is it yours, Ms. Waldrop?
Yes, Your Honor. Is that Miss Stone?
It
Yes.
is.
No, Ms. Stone is the co-defendant in this case, Your Honor, and she is my client.
I have that this defendant's name is Leah Stone. Is that not correct?
Correct.
Yes, Miss Young is my client. She's the co-defendant.
Okay, we don't have Ms. Young yet. We're on Ms. Stone. All right, go ahead, Ms. Waldrop.
Yes, Your Honor. With respect to the count 1, the state would be asking for a $500 signature bond through pretrial. And with respect to count 2, the obstruction, a $1,000 signature bond through pretrial, we'd be asking that the defendant stay away from MARTA, have no drugs or alcohol, and no weapons on or about her person.
All right. And you want to give me the very brief factual basis, Ms. Waldrop?
Yes, Your Honor. I believe the co-defendant rather was the one who allowed Ms. Stone to gain entry into the MARTA station without paying the required fare.
Okay.
And then when the officer Motham, attempted to arrest, she resisted arrest by pulling away.
All right, thank you. Ms. Kim, any
Yes,
objection to the signature bond?
No objection to the signature bond. We would like to just ask for a signature bond through jail. She's only 18 years old and she's a full-time student, Your Honor.
All right. At this time, the defendant will receive a $1,500 signature bond through the jail, 500 count 1, 1,000 count 2. She's to stay away from MARTA in its entirety and have no contact with the co-defendant. Do they work together? Are they family?
Yes, actually, they work together at the same place. I mean, they go to school together, they don't work together. So I
Okay.
was wondering, she has to go to school, so maybe that can be an exception when
All
she's
right.
in school.
We'll just leave it as stay away from MARTA at this
Thank
time.
you.
Since it seems that the no contact may not be practicable.
Hello?
Is there anything further?
Hello, can you hear me, Miss Judge?
I can.
This is Leah Stone's father. I'm speaking. I was
Okay.
invited to the meeting.
I gave her a signature bond through the jail, which means I'm letting her sign her own bond. All right.
Okay. Can I ask you one question, please?
Very briefly, we have a whole calendar to keep going.
She
Yeah.
needs Marta to go to school. There's no way for her to get to the school without she go to Marta, but she will be definitely an upstanding citizen, I promise you. But she needs the Marta to go to school.
Okay,
And Your Honor, just from the state, obviously, we would object. I mean,
I know, I'm
Yeah.
trying to think of how to work that out.
Only
Because
the
I'm not trying to
state-
place an undue burden on her family because of what she has, what has transpired. Okay, Mr. Howard, if I send this through pre-trial and require her to complete community
I
service
think Marta is
as a
the issue though, Judge.
are you able to take her?
You heard me?
It is Marta's issue.
Yeah.
I'm sorry, say again.
Hmm?
I know Marta's issue.
Oh,
I know
I mean,
Marta is the issue. I'm just thinking,
I
you're
mean,
breaking up, Mr. Howard. Say that again.
if you want to, that's fine, but okay. I mean, she
I
gonna
know
need a
you don't.
co-signer because she's 18. I know she on probation, so I per judge anyway.
I know. I'm thinking about that. I know the state's objection. All right, she can use Marta to go to school only and during school hours. If
Thank you, Judge.
she's found on Marta outside of school hours going to and forth, she will be in violation of her bond. It will still go through the jail. All
Thank you
right.
very much.
Thank you.
So Miss Stone, to school, back home. That's it. You understand that? Other than that, you are not to be on Marta. You understand that? All right. Best of luck to you, Miss Stone. We don't want to see you back here anymore. Who do we
All right,
have
thank-
next?
Position 16, Judge.
All right, this is
Your
the
Honor,
co-defendant. Go ahead, Ms. Waldrop.
I just had a brief question. When you say school hours, we're talking what, 9 to 5, 8 to 5?
I'm unfamiliar with when school hours even are, but in my mind, what would you need to be there 7:30 to about
Okay.
5 o'clock in order to make school at 8? I'm assuming.
Okay.
Your Honor, perhaps 7 o'clock, because this is a cosmetic school
Okay,
that they attend.
so we'll say 7 in the morning to about 5 o'clock in the afternoon. All right. All right, this is the co-defendant, Ms. Young. I'm assuming the facts are the same. Ms. Young, your case is 22 CR 0081001E. You're charged with committing certain prohibited acts and obstruction as well with the offense date of December the 2nd. Do you understand your rights? Can she be unmuted just to tell me whether or not she understands?
Yes, ma'am.
All right, thank you. Ms. Waldrop, I'm assuming the facts are the same. Does the state have a different recommendation? And I also have this is her first arrest, which is why I went straight to you.
Is that
Yes, Your Honor. And the recommendation is the same, Judge.
All right. Mr. Howard, you were gonna say something?
I was just saying they were co-defendants. You just send them through the jail too. My recommendation. I mean, it's up to you. I'm just saying.
Okay, thank you. Ms. McLeod, please proceed.
Good afternoon again, Your Honor. My client is 20 years old. She is a student studying cosmetology at the moment. She lives at home with her mom and her older sister and her niece. This is her first arrest. She definitely has expressed remorse to me about this incident. I would ask the court to give her signature bond through the jail, and also that she be allowed to use Marta, because that is how she gets around. She doesn't have a car. Nothing further, Your Honor.
All right. All right, at this time, the defendant will receive the same bond order as the previous co-defendant. She's gonna receive a $1,500 signature bond through the jail, 500 count 1, 1,000 count 2. She can use Marta to go to school, so school hours, what we determined were 7 to about 5, and she's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Excuse me, Judge, I'm sorry. Ms. Stone just came back in the courtroom and stated to me that they banned them from Marta for 60 days.
Oh, well, then they need to comply with all active Marta suspensions. And following the suspensions from Marta, this order will apply. So they must comply with all active suspensions. So that means they're not going to be using Marta for 60 days. Thank you for that information.
Okay.
All right. Best of luck to you both. And that will conclude your case, Ms. Young. Who do we have next?
Next, we have position number 5, Mr. Mark Harwell.
All right, good afternoon, Mr. Harwell. Your case is 22 CR 00809 J. In this case, you're charged with criminal trespass with the offense date of December the 1st. Do you understand your rights?
Yes, ma'am.
All right, thank you. Mr. Howard, please can I have history?
37 total. His last arrest was 2013, driving without a valid license, suspended license. Before that was 06, suspended license. SOB jail was my recommendation for this. I didn't send it to you because I forgot about the reset. So everything is 15 years older for the most part.
Okay. All right, thank you so much. Mr. Taylor?
Yes, Your Honor, the facts of the case are that Mr. Harwell was at the Metropolitan Parkway Apartments. He was a former resident there. However, his lease was not renewed due to multiple lease violations and him threatening staff with a handgun. The officer spoke with the leasing manager at that location, and she stated that this has happened multiple times recently, and she showed the officer multiple cases or papers where he had been issued criminal trespass warnings. The most recent criminal trespass warning was issued November 11th, 2022. I don't think he was arrested because we don't have a case. However, a warning was written for him to stay away. Because this seems like a recurring issue and that a simple stay away, I don't think it's going to be abided. We would ask for a $2,500 surety bond to comply with all of the criminal trespass restrictions and to stay away from 2310 Metropolitan Parkway apartment or the Santa Fe apartments.
All right, thank you. And Mr. Howard?
Yes, Judge. Mr. Harwell is 60 years old. He is a lifelong Georgia resident. His mother still lives here in the Metro Atlanta area. He graduated from Northside High School. Judge, he acknowledges that he is no longer going to be living at the address stated in the warrant. He is being placed in a new facility by the organization that works with him due to his disability, Caring Works. He wasn't able to give me the full address because they're just moving him to that new address. And Judge, he then indicates he doesn't have a problem staying away from that address. He does have new residents now, and he gets about $900 a month for his disability, which they use to provide for him and to help him with housing and other needs that he has. Judge, given that it is a nonviolent charge, there's nothing in his history to indicate he's unlikely to return to court. I think his last arrest was many, many years ago, and certainly being arrested and told by the judge, you need to stay away from that address, I believe will suffice in this instance. We'd ask that he be allowed to sign his own bond, Judge.
All right, thank you. At this time, defendant will receive a $2,500 signature bond through the jail. He's to stay away from the Santa Fe apartments on Metropolitan Parkway in its entirety and have no alcohol, drugs, or weapons as a condition. Is there anything further?
Thank you, Judge.
Your
Best of
Honor,
luck to you.
could the state ask that he be required to complete whatever program that he's going into or to report there so that we have some sort of assurance that that is in fact where he's going?
I'm not going to do that at this juncture, Mr. Taylor, but I do state's argument is duly noted. All right, best of luck to you, Mr. Harwell. Who do we have next?
We have position number 6, Mr. Demetrius Johnson.
All right, good afternoon, Mr. Johnson. Your case number is 22CR008110C. In this case, you're charged with battery family violence with the offense date of December the 2nd. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard?
This is 10th arrest. Last arrest was last month for suspended license registration. On probation, possession of marijuana with intent, possession of a controlled substance with intent. That's 20 SC 174591. Also has history out of the state of Florida. January 2020, possession of drug-related objects, theft by receiving, sale of marijuana. The theft and the possession of a firearm was dismissed. 2019, sale of marijuana. 2017, sale of marijuana. Last arrest in Florida I see 2014 probation violation, 2021 probation. That 2021 probation was possession of 20 grams or less of cannabis. 2014 theft by receiving, that was dismissed. That's it.
All right, thank you. Mrs. Taylor?
Your Honor, the facts of the case are that the defendant and the victim were arguing over a telephone call from another female. The defendant struck the victim with an open hand to the face and nose, and officers were able to observe visible scratches and bruising. The state would recommend a $3,000 surety bond, no contact with the victim, Alexia Williams. That's Alexia Williams. 1 anger management class, and to stay away from 1050 Hammond Drive.
All right, I'm sounding for Ms. Williams at this time. If Ms. Williams is on the Zoom conference and wishes to be heard. All right, hearing none, Mr. Howard?
Yes, Judge. Let's see. All right, Mr. Johnson is 31 years old. He has lived in Georgia for the past 7 years. He recently got a job at Publix as a food prepper. He just started that job. And he has some college. He attended Meritech, where he got a certificate for medical billing. Prior to living here, I believe he lived in North Carolina. And Judge, in this instance, it's my understanding from him that both parties were charged. He indicates that Ms. Williams was given a citation because there was a minor child there. And he tells me that she has a court date sometime in April on the ticket that they gave her. And I believe the warrant that I saw indicated that the officer observed visible injuries for both. If it is in fact true that they were both charged, Judge, it sounds like that the officer may not have been able to determine that he or the other party was the aggressor. And given the inability to make that determination, we would ask the court to allow him to sign his own bond, given that they didn't establish, or it hasn't been established, that he was the aggressor in the case. We did hear the history, Judge, but we would ask the court to consider the signature bond if it can be. I don't know if the state has any information about whether she was cited as well, but that is what he tells me, Judge.
All right. All right, at this time, defendant will receive a $2,000 surety bond. He's to have no contact with Ms. Williams and stay away from that location on Hammond Drive. Should he need to return, he can return one time with a member of law enforcement, and he's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Thank you, Judge. Nothing further.
All right. Best of luck to you, Mr. Johnson. Who do we have next?
Next, we have position number 7, Mr. Langevin.
All right. Mr. Langevin, your case number is 22 CR 008111H. In this case, you're charged with driving under the influence of alcohol less safe, failure to obey signs or control devices, and driving improper erratic lane change, each with the offense date of December the 2nd. You understand your rights?
Yes.
All right. Mr. Taylor?
You want the history? Second arrest.
Oh, I'm sorry, you're right.
Second arrest, 2015 forgery of instrument out of North Carolina.
Okay. All right, Mr. Taylor?
Right. Your Honor, the facts of the case are that the officer observed a black Mercedes stopped at a traffic light. The vehicle was stopped past the stop bar and obstructing the crosswalk. The light turned green and the vehicle continued down the road and drifted into the adjacent lanes. A traffic stop was performed and the officer noticed visible signs of impairment from the defendant, including red eyes, inability to keep his eyes open, thick and slurred speech, lethargic movements, and a blank gaze expression. The officer could also smell the strong odor of marijuana emanating from the vehicle. The defendant did agree to perform standard field sobriety tests and exhibited numerous clues of impairment, and the officer was able to conclude that it was less safe for the defendant to drive. This took place at Medlock Bridge Road and State Bridge Road in Johns Creek. The state would be recommending a $2,000 surety bond in this case.
Broken down as how, Mr. Taylor, just out of curiosity?
We would ask for, let's see, $1,000 on the DUI and $500 on each of the traffic.
Remaining charges. Okay, thank you. Mr. Howard?
Yes, Judge, Mr. Langevin is 32 years old. He has lived here for the past 17 years. He graduated from Salem High School right in Conyers, where he currently resides. Judge, he is gainfully employed full-time, and he has a 2-year-old child that he supports as well. And Judge, we believe, once he has an opportunity, or his attorney, because he won't qualify for our services after today, but he certainly intends to contest the charges in this case. We would ask the court to consider maybe a signature bond on the fatal baseline and the improper lane change charge. If the court is not inclined to give a signature bond on the DUI charge, we'd ask that it be $1,000 bond on that charge, and then signature bonds on the others if the court is not inclined to give a signature bond on all three of those. But given his lack of history, Judge, we would ask the court to take that into account.
All right, thank you. At this time, the defendant will receive a $3,000 split bond. It'll be $2,000 surety on count 1, the DUI, and $500 signature on each of the remaining charges to the jail. He is not to drive without a valid license issued by the Georgia DDS and have no alcohol, drugs, or weapons. Is there anything further?
Nothing further, Judge. Thank you.
All right, best of luck to you, Mr. Langevin. Who do we have next?
Next, we have position number 10, Mr. William Stanby.
All right, good afternoon, Mr. Sanvi. Your case number is 22 CR 008114F. In this case, you're charged with simple assault with the offense date of December the 1st. You understand your rights?
Yes, Your Honor.
All right, thank you. Mr. Howard?
18 total. Last arrest was back in 2020. Ag assault, theft by receiving. That's open in Superior Court. 22 SC 180617. Before that was another 2020 arrest, suspended license and obstruction. He got history out of Massachusetts and Minnesota. I see one cycle in Minnesota 2017. It says 4th degree DWI. That was dismissed. I got a 2018 out of Massachusetts. Threatened to commit crime, disturbing the peace, assault and battery on a police officer. Looks like those were dismissed. I got a guilty for suspended license in 2020. 2015 suspended license. I see a 2015 assault, 2014 assault. It's kind of weird how it's posted.
Is it the same charge?
Well,
Or
it says assault to murder, but I don't know if that's their way of saying ag assault. I'm not sure.
Okay.
But it's 2 different arrests for it. But that's all.
All right, thank you. Ms. Waldrop?
Yes, Judge. With respect to just a brief factual basis, he is charged with simple assault. He did grab his wife's shirt forcefully after a verbal argument. With respect to the state's request for bond, I'm asking for, based on the history, a $3,000 good bond in this case. I'm also asking that the defendant have no further contact with Danielle Sandby, stay away from the incident location of 4732 Campbellton Road, and have no drugs or alcohol or weapons while out on bond.
All right, thank you. Ms. McLeod?
Yes, Your Honor. Mr. Sanvi is 34 years old. He is married and he shares 2 very small children with the alleged victim, a 1-year-old, almost 2, and one who's 6 months old. My client runs a nonprofit music academy. He tells me that he also has a college degree. The prosecution did not mention, Your Honor, but my understanding is that this is a case of a dual arrest. The wife was also arrested because she pulled a gun and shot the gun at him, Your Honor. So I just wanted that to be a part of the record because that is my understanding, that it is a dual arrest. He tells me that his aunt is currently looking after the children, 2 of whom are her children by a previous relationship, and the 2 youngest ones are his children. He tells me, Your Honor, that the house which you mentioned, the Campbellton Road address, is a property, it's a house, and he is the sole named lessor on this house that he's leasing. So he would like to go back there so that he can be with his children and provide a roof over their head, especially those two really young children, Your Honor. He does not object to the no further contact with the alleged victim, but he does want to make sure that he can interact with the children, and so can she. That is the two children, of course, which they share as a married couple. Nothing further, Your Honor.
I'm gonna, is Ms. Sanvi is a co-defendant? Is that information the state had as well? Sorry,
Yes,
there's no point in sounding.
I'm looking at it now. It appears that she was charged and is, I guess, appeared on the felony first appearance calendar. That may have
All
been.
right. All right, hearing that information, Mr. Sanvi will receive a $2,000 surety bond. He's to have no contact with the cross defendant in this case, and he's to have no alcohol, drugs, or weapons. I will not order the stay away. I'm assuming that may have applied to the cross defendant and not this.
You want me to look up the order real quick?
Yes, please. Let's see.
I'll get right back with you in a minute.
All right, we may revisit that part, but for now, we won't put the stay away in. All right.
What's the victim's name? Across the defendant?
Danielle Sanvi.
Sanvi. Oh,
I got it, Judge.
Okay.
So,
Was the stay away ordered?
no, it just says no further violent contact with William Sandy and children, no weapons. So she got a $45,000 good bond, and it just says no further violent contact with the victim and the children and no weapons.
that is true.
Okay. All right. So
The case number is 22 CP 214399.
all right, we'll amend the bond to have those same conditions then. It'll be a $2,000 surety bond, and he's to have no further violent contact with Ms. Sanvi.
Thank you, Your Honor.
All right, best of luck to you, Mr. Sanvi. Who do we have next?
Next, we have position number 11, Mr. Shepherd, Tommy Shepherd.
All right, good afternoon, Mr. Shepherd. Your case is 22 CR 0081038. In this case, you're charged with simple battery family violence with the offense date of July the 2nd of 2022. You understand your right?
Yes, ma'am.
All right, Mr. Howard, can I have the history, please?
34 total. Last was 2017 parole violation. On probation, possession of heroin with intent. That's 06 SC 47462. In 2010, they gave him 10 years to serve, 10 years probation. The underlying charge for that parole was ag battery too. 2014, failure to appear, suspended license was dismissed. 2014, simple battery family violence arrest. 2014, suspended license NOLO. 2013, parole violation. 2013, theft by receiving motor vehicle. 2013, failure to appear. Ag battery, possession of a Schedule 1, ag assault conviction, 2009. Want me to keep going?
No, that's good. Thank you. Ms. Waldrop, please proceed.
Yes, Judge. Brief factual basis. This incident occurred when the defendant came into the home of the victim where she was with her children. She and the defendant had recently broken up. He came in intoxicated. They got into a verbal argument. The victim actually went upstairs specifically to get away from the defendant, who then followed her. He attempted to mush her in the face, and when she blocked his attempt, he then struck her in the upper left cheek with a closed fist. So the officer did not observe any visible injuries. However, given the history and the factual allegation, state would be requesting a $3,000 good bond on the charge, a stay away from 418 Lovejoy Street, no further contact with Miss Audra McCluster, no drugs or alcohol, and no weapons on or about his person.
All right, thank you. I'm gonna now for Ms. McCluster before we go to Ms. McLeod. Ms. McCluster, if you're on the Zoom conference and wish to be heard, this is your opportunity to speak. All right, hearing none. Ms. McLeod, please proceed.
Yes, Your Honor. My client is 50 years old. He shares 3 children with the alleged victim, Your Honor, a 16-year-old son and 2 daughters, 14 and 13. He tells me that he has been exchanging these children with the alleged victim for weekend visitation, and he has been doing so since earlier this year. He denies, in fact, he tells me he's totally unaware of this allegation. He says because they have not interacted for a long time. Yes, they had been in a relationship before he was incarcerated, but they did not resume the relationship based on what he tells me after he was released. And he has not been interacting with her like that. He doesn't have a telephone number for her. He says all he does is he goes and he takes the children back and forth. And that has been continuous right up until his arrest. And he has never gone into her house like that. And he denies that this alleged incident even occurred, Your Honor. I would note that the warrant says that it occurred in July. He still has been continuing to pick up the children, and he says, it's all news to him. He tells me that he has not had any interaction with her at all since he came out. So he totally denies this allegation, Your Honor. I acknowledge that my client does have some history, Your Honor, but I would ask the court to give him a reasonable bond so he can get out of jail, get back to his job. He is gainfully employed as a forklift operator, standing forklift operator, he tells me, Your Honor. And apparently he does have a really good relationship with his 3 children. Nothing further, Your Honor.
All right, at this time, defendant will receive a $1,500 surety bond. He's to have no contact with Ms. McCluster. He can arrange transport of his children through a third party, and he is to stay away from that incident location, have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further, Your Honor. And this concludes my business before the court today. May I be excused?
Yes, Ms. McLeod, enjoy the rest of your weekend. Take care.
Thank you, Judge. You too.
Okay, bye-bye. All right, who do we have next?
Next, we have position number 12, Mr. Mark Smith.
All right, good afternoon, Mr. Smith. Your case number is 22 CR 00810-8D. You're charged with driving improper erratic lane change and DUI that's safe, each with the offense date of December the 3rd. Do you understand your rights?
I do, Your Honor. Yes.
All right, thank you. Mr. Howard?
First arrest.
All right, thank you. Ms. Waldrop? Ms. Waldrop, if you're speaking, you're muted.
I apologize, Judge. Can you hear me now?
Yes, we can.
Okay. Your Honor, with respect to this case, the defendant was stopped after he made a right turn from the straight lane. After the officer initiated a traffic stop on his vehicle, he could smell the odor of alcohol from inside of the vehicle and noticed that the defendant had a blank gaze or expression on his face and that his eyes were bloodshot and glossy. The defendant also seemed disoriented when asked questions by the officer. Upon exiting the vehicle, the defendant had to use the truck door to support himself as he stepped out. And at that point, the officer could also smell the odor of alcohol coming from the defendant himself. The officer did request field sobriety evaluations as well as read and implied consent and requested a state administered test after arrest, to which the defendant refused both. With respect to the state's request for bond, we would be asking on the improper lane change for a bond of $500 straight, and on the DUI less safe, a bond of $2,000 straight. We would ask that the defendant have no drugs or alcohol while on bond, no weapons on or about his person, and that there be no driving without a valid driver's license.
All right, thank you. Ms. Kim? You're muted as well, Ms. Kim.
I apologize. Mr. Smith has been here in Georgia from 1994. He is 42 years old with 3 minor children, and he's married, and his parents and brother and sister, they're all here in Georgia. He also is gainfully employed at software company as a project manager. He's been working there for more than 6 years. And Your Honor, he has a bachelor's degree from Emory University, and he's not going to be qualified for public defender's service. So my representation will end at the end of the bond hearing. We would like to request for a signature on bond. This is his first ever. So we kind of want that to be considered. And that's it, Your Honor.
Thank you. At this time, defendant will receive a $2,500 split bond. That'll be a $500 signature bond through the jail for count 1 and a $2,000 surety bond for count 2, the DUI. He is to have no alcohol, drugs, or weapons, and he's not to drive unless he has a license issued by the Georgia DDF. Is there
Thank you,
anything
Your Honor.
further?
Nothing further from defense.
All right, best of luck to you. That concludes your case. I believe we only have position 14 left, the case of Connor Tremiar, is that correct?
Yes, Your Honor.
All right, Mr. Tremiar, do you understand your rights?
Yes, ma'am.
All right, Mr. Howard, can I have the history, please?
Yes, third arrest. Last arrest was 2021 for a fray out of Haversham County. He got PTI that was dismissed last month. Before that was 2020 trespassing for battery DV. Those were dismissed out of Gwinnett.
Right, thank you. Ms. Waltrip?
Yes, Your Honor. Just a brief factual basis. Your Honor, this charge stems from an incident in which the defendant essentially attacked the victim unprovoked. He hit her multiple times in the face, causing a black eye as well as a bloody nose. The warrant initially indicated that there could be a possible broken nose in this case, and we've since accusing the case have learned that the victim's nose was in fact fractured. So obviously, later down the line, state will be seeking to have this case reviewed by the DA's office for possible felony transfer. At this time, though, I will ask for, based on the facts, a $7,500 straight bond. I'm asking that the defendant stay away from the location of 777 Memorial Drive, that is the RT Dairies Apartments, that he have no further contact whatsoever with the victim, Miss Asia Thomas, no drugs or alcohol, and no weapons on or about his person.
Right, thank you, Ms. Waldrop. Is Ms. Thomas on the Zoom conference? I do not see her, so we will go straight to you, Ms. Kim.
Yes, Your Honor. Mr. Tremier, he is 20 years old, Your Honor, and he has been here in Georgia for the last 9 to 10 years, and he has his parents and families here in Georgia. He has a strong ties to the community, and also he graduated from high school, and he has been working as a traveling nurse for the last 2 years. Your Honor, he does not reside with Miss Asia, and also they do not have any contact whatsoever, so no further contact, stay away from her is completely fine with my client, and my client denies the allegation, and we would like to request for a signature on bond for this particular incident. And yet, if Your Honor is not inclined to give him a signature on bond, we would like to ask for a maximum $1,000 good bond. Thank you.
All right, at this time, defendant will receive a $4,500 surety bond. He is to have no contact with Miss Asia Thomas and stay away from that incident location. He's to have no alcohol, drugs, or weapons as a condition.
Your Honor, that incident location was actually his mom's place, where he resides with, and Miss Asia does not live there, and she actually is in, I believe, another place, completely different place.
All right, well, what we'll do is just to ascertain, did the state request to stay away from that address, Ms. Waldrop? Was that also
Your Honor, we did stay away from that address.
What we'll do is we'll have him return one time with a member of law enforcement to make that determination as to whether or not Ms. Thomas resides there. She does not, he can return there and move about there freely. Is there
Thank
anything
you.
further?
Nothing further, Your Honor.
All right, I believe that concludes the entire calendar. Mr. Jordan, will you review it for me, please?
Position 1 is a $2,500 surety bond reset SAP. Position 2 is a $3,000 sign-on bond pretrial. Position 3 is a $1,000 surety reset SAP. Position 4 is a $10,000 surety reset SAP. Position 5 is a $2,500 sign-on bond jail. Position 6 is a $2,000 surety reset SAP. Position 7 is a $3,000 split bond, $2,000 surety on charge 1, and a $500 sign-on bond jail on charge 2 and 3. Position 8 is a $3,000 sign-on bond through pretrial. Position 9 is a $2,500 sign-on bond jail. Position 10 is a $2,000 surety reset SAP. Position 11 is a $1,500 surety reset SAP. Position 12 is a $2,500 split bond, $500 sign-on bond jail for charge 1, and $2,000 surety for charge 2. Reset SAP. Position 13 is a $1,500 sign-on bond jail. Position 14 is a $4,500 surety reset SAP. Position 15 is a $2,500 sign-on bond jail. Position 16 is a $1,500 sign-on bond jail. And that's it.
Judge, we thank you.
Any comments, changes, corrections, or questions? All right.
I second that motion.
All right.
Have a great weekend.
We could have been here a lot longer.
All right. Hearing none. You all take care. Have a great weekend. I'll see some of you all next week.
All right.